walking out. Just right behind her, I see Dominic Ayene, former deputy attorney. I see Joyce Bauer, who spoke for.
Now ask, for instance, in Tema Central, the EC comes to court to say that the two bridges were in dispute, so they could not be collated. Now the court says they should go and collate those two bridges. How do you collate something that is in dispute? That is my question for the court. How do you collate two bridges that the NDC is disputing on grounds that they were fabricated by the EC officers?
Is that to say that you don't agree with the court?
I disagree with the court. Now, the evidence before the court in respect of Tema Central, uncontroverted, was that it was not the case that, as alleged by the applicant, that there was no collation. Indeed, there was a collation and a declaration, but that out of 148 benches, 146 were collated, save 2 that the NDC opposed. Now we oppose those 2 benches on grounds that they were fabricated after the close of polls on December 7th at 5 p.m. Now we invited the presiding officers in respect of those 2 polling stations. They came to admit that when the polls closed, they were tired, they were exhausted, so they brought the pink sheets to the office of the EC, and they were instructed by their EC Metro director to complete them. How do you complete a pink sheet in the office of the EC after polls have closed?
Were you giving copies of these?
They gave us the duplicates. The duplicates, therefore, the duplicates that we have, the pink sheets in dispute. I want everybody to appreciate this matter today. The 2 pink sheets in dispute in Tema Central, the duplicates that we have, that was how I was able to detect it. The duplicate did not contain the information contained on the original that the EC was urging upon us to approve. Why? The duplicate that we have did not have the name of the presiding officer, his signature, the year of the elections, and the time of close of polls at the polling station, and date. That is the year of the election. That's the date. This was a requirement in pursuance of Regulation 43 of CI 127 and Regulation 3923 of CI 127.
You have a right to
hold on. So we disputed. And they were insisting that it should be admitted. This was what generated the entire controversy. Today, so if the court says, in view of all this, by a mandamus application, go and collect it, do you think me, the farmer, I will agree that those 2 benches be collated when they are in this? No. It is not a mandamus that will correct it. It is a full-blown trial, so that the person who deposed to affidavit that the benches were in dispute, who will be put on the stand. Then I'll cross-examine him. That you have admitted that the benches were completed, for instance, in your office after our agents, of the polling agents of all the contestants have left. So the law does not permit you to complete pinches in your office and come and give to candidates to accept.
So obviously you disagree.
Of course we disagree.
What's the way forward?
I think we advise ourselves, and I'm sure by the close of the day, you know the position of the party.
Because you have less than 2 days to go.
Yes, I'm saying. We are working today, Saturday. Right now where we are, tomorrow is even material as a non-working day. We can be working tomorrow. So by close of today, the party's position in this matter, you will be advised and you will know. But this is not the end.
This is Tema Central. Would you throw some more, share some views?
In fact, if we were in court, the court appears to be rehashing the same facts in respect of all the other respective constituencies. So, for instance, the Tema South, the judge mentioned 62 pin sheets, when indeed that was not the issue in respect of the Tema South. Okaikwei Central, there were not 62 pin sheets. The judge was mentioning 62 pin sheets.
So the judge corrected himself.
Why? When
yes, it was rehearsed.
Who corrected him? Gary Numaku corrected him from the bar. Do you stand at the bar and correct the content of a judgment being delivered by a judge? You bring an application on notice for correction of judgment in terms of facts.
it be an
It
accepted
could not.
mistake?
It could.
Looking at how the various judgments
I will not go on that path with you. I am saying that where a lawyer stands at the bar and be correcting the content of a ruling by the judge, we have a problem.
Yes,
We have a problem.
For Tema, that appears the NDC.
You can't bring it to a revolutionary and expect us to go down. No, man. This is fuel for what needs to be done. So we'll keep pressing on, we'll keep fighting.
We'll fight to the end.
That is our duty.
That is it.
And we'll not run away from it.
Inshallah.
Never run away
to the end.
I beg you, don't run.
An applicant comes to court to say that, for instance, there was no collation in Samatic Central, that the judge finds that there was a collation, save for two. When in respect of those two, the evidence to deposed to was that they were in dispute, they were disputed by the NDC. So if two pink sheets are in disagreement, how does a judge order that they should be collated? It cannot be. This is not the process to make that order. It has to, evidence must be led and recanted. That process means somebody must testify for me to cross-examine the person on oath. So we have made the point that mandamus is not a solution for the problem on the ground, because the problem on the ground is a major disagreement. So you cannot order a person to go and do a collation where the collation, the disputes are still alive. The disputes are not resolved. And mandamus does not resolve disputes. It is a full-blown trial.
What's the way forward?
Like I said in court, you can only oblige what the judge has said. But I must say that it is something that we anticipate. So we came to court prepared with an notice of appeal. And as you can see, immediately the judgment was read, we ran to the registry to file the respective notices of appeal in respect of the four affected constituencies, as you can see. So with us here in the notice of appeal and the subsequent stay application. It is something that we knew was going to happen with the ruling on the prelim. It was clear when the judge was told. And so we took preemptive steps to do what is needed. So I can tell you, and as you can confirm, we have the respective notices of appeal. We have them here, and we'll take steps right now to get them, the legal requirement. The order must be served on the Electoral Commission. And like my law said, we are now working on the order. We have our say, application, we have the notice of appeal, and we take steps. This matter is not ending here, and let nobody be deceived. This matter cannot end here, because you see, the matters raised, and if we're in court, it was as though my Lord was hearing an election petition.
This is a mandamus application, for Christ's sake. And that is all that I will say. So we'll take all the steps.
In all of this, time is
also
of
running out.
essence.
Time is
How does
running
it
out.
affect
How
your
are you
case?
dealing with the election? Because that election and the nature, expeditions prior notification, and we have taken steps. Continuously, look at the time the judgment on the rulings were delivered, and look at the time we filed our respective notices of appeal. That is the speed with which we want to do, and we have taken it. Thank you, Honorable.
No, Okaikwei Central.
The wind to finish.
Sorry. And make sure that we didn't have a chance to deal with evidence as it's supposed to be, which is where we see
was allowed. But in Tema Central, which is in this view, the official who declared is not being has been ruled by the court to be not the official person to do so. Don't you think that it is time that whoever drafts these policies or documents for elections, we need to sit down and look at some of these loopholes so that future elections wouldn't be having some of these issues?
You see, I've been saying it time and again. It's just that we have crooked officers at the Electoral Commission. Very crooked electoral officers. Why am I calling them crooked electoral officers? Like what you are just giving. The CI is very clear. We all commit ourselves to the CI 127 in declaring resource collation and all that. If you are not satisfied with a declaration, you know where to go. Under PNDC law 284, subsection 16 and 20, that is where you go on petition application, you apply against a declaration if you are not satisfied. It doesn't lie in the mouth of those commissioners who have created all these problems for Ghana, creating security problems. To the extent judges are now ruling that they should come with armed police. They should go and bring even the Israeli soldiers. We don't care. Let me tell you, the thing is that the people have voted massively for NDC. They are pained. They don't like it. They are not happy. NDC for.
Where similarly, we saw some NDC officials or supporters, covering around the EC to declare the videos we saw in court. They were around the EC. Trying to, I don't know what they were doing, but when the EC was declaring, they were around. Don't you think it's duress? Lame person.
You see, your definition of duress is different from the court ruling of duress. Okay. The way I would define duress, I can describe what you are doing now under duress. But I should process to find out whether actually the action I took was under duress or not. It doesn't lie in the mouth of Jim Mensah commissioners. That is the problem we have in Ghana. Look, this kind of, if you allow it to stay, next election, you see the kind of thing will happen. Yeah. If we allow this charade, we will declare people, we will go and tell them that declaration was not done properly. Yeah. We won't accept it because they were declared under duress. So all the 40-something constituency declared for MPP in Ashanti region, should we come and tell them that it was done under duress? Yeah. So, should we say it was done under duress? These are a travesty of justice. We won't allow it. Yeah. We are not going to allow this.
Mr. Tanko, if you look at all the argument before the court recently, what the court said was that the elections are not complete. Why won't you follow the process so that all the polling centers are declared, then the winner is declared?
Have we cross-examined them to know that the election was not complete? That is their story. That's why I describe a bucket.
Agree with them.
A bucket full of lies, pour in front of the judge, and he succumbed to those lies. How can you listen to people like that? Okay, if I walk to the court and tell them that somebody came to my house and attacked my place, vandalized and took all my monies away, so the judge should just rule that this man, you are a thief, you have stolen because the man said this and that. Is that how you rule?
But if
We must cross-examine them.
Between now and Monday morning, do you think anything can be done to arrest this particular?
Yes, we have filed a process. The bailiffs are their way. They have shown the LPP there. IGP, as we speak now, I'm told they've already sent to them. If they provide security for this illegal thing, we'll come after them. I'm saying this because that's lawlessness. You must respect the court. The court made a ruling. We also filed another process arresting the ruling, stay execution, so that we appeal against it properly. Because what he has done, it appears there is some evil hands somewhere.
Yes.
Because not all of them have 62.
Yeah.
But he continued mentioning 62. Where did he get the 62 from? Who was him? And then they didn't see the interest in our opponents were rather providing evidence for him to continue to be laughing. He was exposed badly in open court. I didn't force him to do that. You see how God works. They don't like Boamah victory, but he has won. So it pained them. They continue doing this kind of shit.
A factual mistake that could easily be corrected.
Really? He did the factual mistake twice, not once, twice.
He corrected himself.
They continue. They corrected him.
They corrected him.
So what did he say about that?
Figures.
It has to do with what?
Figures.
So now anybody who sits at the high court judge and somebody come and tell you a pack of lies, you accept it and say that because of what he said, I'm going to rule in favor of him. That is what has happened today. You were in the court. I was seated with you. Is it fair? Is it fair to we the interested parties? No. And you want NDC to allow this one, we won't allow it.
One important
we will follow it in casket.
One important thing in this whole matter has to do with time. How favorable is time to your fight?
We are talking about justice, we are talking about time. The matter has been arrested by the application we have filed. The process has been arrested. So we are nobody should go and do any re-collation. If they try, that's lawlessness. Don't forget, in 3 days' time, we have a lot of reset. Anybody who involves himself in lawlessness will be reset. Okay. That one they are telling them. And we are not going to mince words. Ghana deserves better. Yeah. We can't continue this. We are becoming a funny country with this kind of charade going on. Look at the first one. He has to be sidestepped. Another one came. I've just told this man went on retirement, they brought him back. And we say them for this. These are the allegations. And we are investigating it further. Look at the kind of
second. But the steps that your team has taken, clearly, these constituencies will not be part of those that will be sworn in by Parliament.
Yes, we are going to stop it. The first declaration stands. Okay. We'll make sure that we'll send them. Those 4 people, they were declared winners. We are going to send them. They will be declared on Monday in Parliament. They will be sworn in. Okay. Watch and see how we play the game. Yes.
Thank you very much, Mr. Tanko.